Welcome to Business Law 280 review of Chapter 15, Illegality. This chapter is designed to teach you about the circumstances under which a contract cannot be enforced because it violates public policy. After reading this chapter and reviewing this lecture, you should be able to do the following. 1. Explain the concept of illegality as it is used in contract law. Determine when a contract that violates the language or policy of a statute is likely to be illegal. Analyze whether a given non-compete clause is likely to be enforceable. Analyze whether a given exculpatory clause is likely to be enforceable. Explain the concept of unconscionability and identify the circumstances that make a contract unconscionable. And finally, determine the effect of illegality in a given scenario. In our opening vignette, we have Wilson, who had been licensed to practice architecture in Hawaii, but his license lapsed in 1971 because he had failed to pay a required $15 renewal fee. A Hawaii statute provides that any person who practices architecture without having been registered and without having a valid, unexpired certificate of registration shall be fined not more than $500 or imprisoned not more than 1 year or both. In 1972, Wilson performed architectural and engineering services for a ranch and billed that ranch more than $33,000 for the work. You should be able to answer by the end of this lecture whether this contract is legal. Would it matter if Wilson had never met the licensing requirements to be licensed in Hawaii? And is the ranch required to pay Wilson anything for his work? So let's start with the meaning of illegality in general. Illegal does not necessarily mean a violation of criminal law. More commonly, it means it's a violation of some sort of public policy. An agreement will be unenforceable because of illegality if it involves an act or a promise that violates a law, any law, or is against public policy. There are three types of illegal agreements. There are agreements that violate statutes, agreements that violate public policy, and agreements that are unconscionable and contracts of adhesion. When a contract is held to be illegal, courts generally refuse to enforce it, even if it was a clear, voluntary agreement between individuals who had capacity to contract and was supported by consideration. This area of contract law involves the weighing of competing public policies. The public policies that favor allowing people to order their own relationships through contracts on the one hand, versus other public policies that may be adversely affected by the contract. In our first case of Coma Corporation versus Kansas Department of Labor, we had an undocumented worker who sued his former employer for earned but unpaid wages under the Kansas Wage Payment Act. The employer claimed that the Kansas Act was preempted by the Federal Immigration Reform and Control Act and that the employee's employment contract was illegal and void. The court had agreed and held that the contract was illegal, but on remand, it sent it back for a calculation of payment based on the applicable minimum wage. So the first thing was whether or not federal preemption applies. The court first addressed whether the Immigration Reform and Control Act, IRCA, preempted the State Wage Payment Act, where a state is specifically afforded the ability to regulate certain conduct. Federal preemption will not apply. The court then addressed Coma Corporation's specific argument that the contract itself was illegal. The court looked to the nature of the statutory scheme. Where a statute imposes sanctions but does not specifically declare a contract invalid, then the court needs to look at whether the legislature intended to make contracts unenforceable. Here, the statute did not specifically declare contracts of aliens to be void. It simply read that an alien who enters the country and performs work without having received the necessary certification, then that person will be ineligible to receive a visa. It did nothing to talk about the contracts of employment that that person enters into. Second, the court looked to the equity and fairness of the transaction. Here, Coma Corporation knowingly participated in the transaction and should not be able to profit at the expense of the employee. Finally, the court looked at the deterrent effect. The purpose of the statute was to safeguard the American labor from unwanted competition. If Coma Corporation does not have to pay the undocumented workers, then the objective of the statute would not be fulfilled because employers would be able to knowingly hire excludable aliens with impunity and then refuse to pay them for their services. So let's look at how the appellate court actually went through their analysis. The issue was, does a worker's immigration status affect his right to receive fair wages as a matter of public policy? The rule that the court came up with first was federal preemption is not automatic. States enjoy broad authority under their police powers to regulate employment relationships to protect workers in their state. In applying the rules to this case, the court said by denying earned but unpaid wages on the ground that an employment contract is illegal would directly contravene state law. Therefore, the district court erred in holding that the contract was illegal. Now note the different functions that the court engages in when it determined whether a contract was illegal. It interpreted statutes, it weighed the strength of various policies, declared policies of their own creation. Now, the decision to hold a contract illegal is not a knee-jerk reaction every time a contract interferes with public policy. Courts will consider the extent of the interference with the public interest, even when one of the parties has violated a statute. So now what happens if the agreement is in violation of the statute? Federal and state legislatures enact statutes that declare certain types of agreements unenforceable, void, or voidable. Certain agreements are specifically declared illegal by statute. Those are usury statutes, Sunday laws, wagering statutes. They say any type of agreement that falls under those laws are invalid. They are void as a matter of law. There are certain agreements that violate public policy, even if the statute does not expressly address the validity of the contract. The public policy may be manifested within the statute. Those are agreements to commit a crime, agreements promoting an illegal purpose. Think of contracts that don't expressly mention committing a crime, but in order to complete it, a crime would potentially have to be committed, such as speeding. Agreements to perform an act for which the person is not properly licensed. The nature of public interest protected by those types of statutes will determine the outcome of the case to a large extent. The key factor is to focus on whether the statute is regulatory in nature or revenue-raising in nature. If the statute's purpose is to protect the public, then the agreement will be unenforceable. If the statute's purpose is to raise revenue, then the agreement is enforceable. And finally, you might have agreements in restraint of competition, which we get to in the next learning objective. There are certain agreements that are found to have violated public policy as declared by the courts. Courts have traditionally had broad powers to declare public policy. Before the age of codification, courts often had the primary responsibility of doing so, at least with respect to determine what contracts would be enforced. A primary example of this is the policy against restraints on competition, which was originally developed by the courts, but is now reflected in both federal and state antitrust legislation. Public policy changes with social, economic, and technological progress. Courts would have treated contracts between unmarried cohabitants 100 years ago much differently than they would treat them today. So let's focus on restraints on competition. If the sole purpose of an agreement is to restrain competition, it violates public policy and is illegal. If the restraint on competition was part of an otherwise legal contract, the result may be different because the parties may have a legitimate interest to be protected by the restriction on competition. For instance, an ancillary covenant not to compete may be found in employment contracts and provide that an employee agrees not to engage in the same type of service for a specified period in a specific region after termination of employment. Such non-compete clauses may also be in contracts for the sale of a business or partnership agreements. Courts will enforce such non-compete agreements if they meet 3 criteria. 1, the clause must serve a legitimate business purpose. 2, the restriction on competition must be reasonable in time, geographic area, and scope. And finally, the non-competition clause should not impose any undue hardship. Generally, overbroad non-competes will not be enforced. The Clark sales contract dealt with an overbroad non-compete clause. Clark's is a family-owned business that is involved in high-end builder-distributor appliance sales and services. Smith, who worked for H.H. Gregg for 4 years before commencing with Clark's in 1998, acquired knowledge and expertise of the appliance sales business during his 14 years with Clark's. In 2004, Smith signed a non-compete agreement which stated upon his termination or resignation, he shall not solicit services to any competitor of Clark's, and he will not work for a competitor that resides within a 50-mile radius of Clark's. The non-compete was to last for 2 years upon Smith's termination or resignation. Prior to his resignation on April 13, 2012, Smith emailed proprietary information to his personal email, and 5 days later he accepted a job at Ferguson's, which is a direct competitor of Clark's that resides within 50 miles. The court held that although the non-compete served Clark's legitimate business interest, the non-compete was far too broad and indivisible in nature, rendering the blue pencil doctrine inapplicable and the entire provision was unenforceable. So how did the court get to that conclusion? Well, it started with the issue of whether the non-compete clause was enforceable. A non-compete clause will be enforced if it protects a legitimate interest and the restrictive covenant is reasonable in scope as to the time, activity, and geographic area restricted. The court had recognized that Smith built goodwill with his business accounts and referral network over 14 years, and that such goodwill is a legitimate protectable interest of Smith. The judgment for Smith stood. The covenant, as drafted by Clark, was not clearly separated into divisible parts such that the court could strike the unreasonable restrictions. So if they had been able to separate those into parts, what the court would have done under the blue pencil doctrine was to simply strike out those provisions that were unenforceable and leave the rest of the non-compete clause. Here, they had to strike the entire thing because they could not parse it apart. Now, what about exculpatory clauses? Slightly different than a non-compete clause. An exculpatory clause is a release or a liability waiver that attempts to protect a party from liability or damages. Exculpatory clauses may be suspect on public policy grounds, but courts generally will not interfere if the waiver is not a threat to public health or safety. Even if it's not against public policy, a court may still refuse to enforce a contract that is unconscionable as a contract of adhesion or some other showing of abuse of bargaining power. The YMCA case dealt with a contract of adhesion. The case involved an exculpatory clause used in the context of a fitness center. Walters joined the YMCA, signed a contract including an exculpatory clause where he agreed to hold the YMCA harmless for any injury on the premises. 3 years later, he slipped at the YMCA and then sued. The YMCA sought to enforce that hold harmless clause. The trial court agreed with the YMCA and granted a motion for summary judgment based on that exculpatory clause, and Walters appealed, saying that the accident was caused by negligently maintained stair tread and that overcame the exculpatory clause. Classical contract law did not normally concern itself with fairness of the contract, so long as the contract was not induced by fraud, misrepresentation, duress, mistake, or undue influence. These rules serve the purposes of predictability and stability, meaning one could count on his deal being enforced, and it permitted businesses to shift many of the risks they created. The doctrine of unconscionability is a significant departure from that posture taken by classical contract law towards fairness in contracts. The increased use of form contracts, disparity in bargaining power, less interest in protecting capital of business today than in early days of industrialization, all have led the courts to be more willing to evaluate the fairness of a contract than they would in years past. In the YMCA case, after Walters was badly injured, the court had to explore whether the fitness center or health club could insulate itself through an exculpatory clause from the ordinary common law duty owed by all businesses to its invitees. After finding that there was a breach of duty to the YMCA, the court had to answer whether the exculpatory clause, which limited liability for any injury while on the premises, not just while using the equipment, could be enforced. So let's look at the issue, whether a fitness center or health club can insulate itself through an exculpatory clause from the ordinary common law duty of care owed by all businesses to its invitees. The court said there exists a duty not to engage in reckless or gross negligence. Business owners are held to a standard of care congruent with the nature of their business. Exculpatory clauses are enforceable if 4 factors are present. 1, it does not adversely affect the public interest. 2, the exculpated party is not under a legal duty to perform. 3, it does not involve a public utility or common carrier. Or 4, the contract does not grow out of an unequal bargaining power or is otherwise unconscionable. Here, Walter's accident and resulting injuries occurred when he slipped on a step and fell in a common area as he walked to the indoor pool. His injuries did not result from using any of the equipment itself. If applied literally, the exculpatory clause would eviscerate the common law duty of care. The court then concluded that a health club cannot insulate itself through an exculpatory clause from the ordinary common law duty of care owed to its invitees. So what about unfair agreements? Let's look closer at contracts of adhesion and unconscionable contracts. Unconscionability is decided on a case-by-case basis where the court looks to determine if there was the absence of meaningful choice together with terms unreasonably advantageous to one of the parties. Unconscionability specifically comes from UCC 2-302, and it gives the courts power to refuse to enforce all or a part of a contract for the sale of goods or to modify the contract if it is found to be unconscionable. And it looks at both procedural unconscionability and substantive unconscionability. In Singh versus Uber Technologies, the court examines whether a plaintiff, an Uber driver, can be compelled to arbitrate his claims. The plaintiff alleges the gross unequal bargaining power and unconscionable terms. Much of the contractual language has been reproduced in your book, so you can analyze the contractual provisions yourself. When looking at procedural unconscionability, the court looks to the process by which an agreement is reached and the form of an agreement. Here, the plaintiff was presented with a 30-day opt-out provision to choose either arbitrating or litigating his disputes. The court held for Uber, finding the plaintiff did not establish a likelihood of incurring a prohibitively expensive cost. As the same case illustrates, many unconscionability cases involve arbitration clauses. Unconscionability is a primarily consumer-driven doctrine, but it has been used by some commercial parties, such as those who are in inherently dependent positions, such as franchisees, and small businesses who are relatively disadvantaged in their knowledge and bargaining power. The concept of unconscionability has also been adopted by courts outside the reach of Article 2 of the UCC, such as in landlord-tenant agreements. Contracts of adhesion are different than unconscionability. These are usually a standardized form offered by a party who is in a superior position on a take-it-or-leave-it basis. A court will enforce a contract of adhesion unless the terms are harsh or oppressive. So think of click wrap agreements, browse wrap agreements, shrink wrap agreements. Those are all contracts of adhesion. So now if we found that a contract was illegal, what's the effect of that? As a general rule, courts will refuse to give any remedy for the breach of an illegal agreement, meaning if a court finds that an agreement was illegal, it will not give a remedy for breach of that agreement and will not permit a party who fully or partially performed to recover what he or she parted with. That is a hands-off approach. There are a few exceptions to this general rule. If there was excusable ignorance of facts or legislation, if the rights of the parties were not equally in the wrong, if there was rescission before performance of an illegal act, and if the contract is divisible. Those are the only situations in which a court will get involved in enforcing an illegal contract or giving some remedy once a contract is deemed illegal. The Gamboa versus Alvarado case was an example of where the court examined the rights of the parties who were not equally in the wrong. In this case, Alvarado engaged in a fraudulent scheme to obtain U.S. citizenship for various plaintiffs, Gamboa, Nava, and Lopez, if they paid him $15,000 by the end of June 2006. Alvarado pressured plaintiffs into paying him on time. However, Nava did not pay until October of 2006. Alvarado stated that there would be some delay in obtaining the citizenship documents due to the tardy payment. In February of 2007, Alvarado convinced Gamboa to fly to the U.S. to obtain his citizenship documents. In doing so, Alvarado told Gamboa to purchase the plane tickets through Alvarado's business. However, prior to Gamboa's departure, Alvarado stated that Gamboa would be unable to obtain the documents. Alvarado made himself unavailable until March of 2009, where he said that there was nothing to be done because they were all swindled by an unknown player, Castellano. The plaintiff's complaint alleged Alvarado engaged in numerous instances of unfair and deceptive practices. Alvarado asserted the entire complaint should be dismissed because the agreement between the parties was an illegal contract. The trial court granted Alvarado's motion to dismiss. The appellate court notes there was no question that the verbal contract between the defendants and the plaintiffs was illegal and involved a scheme. However, the plaintiffs were not seeking to enforce the contract. They were seeking to get their money back from the defendant on the basis of the fraudulent contract. The appellate court held that because the plaintiffs were not in pari delicto with the defendants that they engaged in the illegal services for. The policy behind the holding was that the Consumer Fraud Act was designed to protect the types of victims such as the plaintiffs in the case at bar. Individuals cannot be allowed to use the very illegality of their own agreement as a way to avoid the consequences of their actions. The matter was reversed and remanded. So it was important in this case that the plaintiffs really didn't know that this was a scheme and that this was an illegal way to get the U.S. documents. For a good recap and flowchart of the effects of illegality, look to Figure 1 on page 479 of your text. So let's circle back to this opening vignette that we had about Wilson being licensed. His license lapsed, he entered into a contract, and he charged more than $33,000 for the work. Is this a legal contract? Yes. This was an actual case, and the court there ruled for Wilson on the ground that the fee aspect of the statute was a revenue-raising fee rather than a regulatory measure. The court therefore concluded that the annual fee provision of the statute was not intended to protect the public and that it is unlikely that the legislature intended unenforceability of contracts. Would it matter if Wilson had never met the licensing requirements to be licensed in Hawaii? Yes. The licensing requirements themselves, not just the renewal fee, are designed for the protection of public. A contract in violation of that regulatory statute will not be enforced. Is the ranch required to pay Wilson anything for his work? Yes. It must pay him the sum agreed upon because the contract was valid. If, though, under the second circumstance, Wilson had never been a licensed architect, the court could refuse to give Wilson any remedy. Unjust enrichment does not apply to illegal contracts. So that's the end of our review of Chapter